Welcome back, welcome back. This is Nico from Unicorn Riot. This is Unicorn Riot's coverage of the day 12 of the Kenpotter trial. Kenpotter's on trial for facing 2 counts of manslaughter, first degree and second degree, after she killed Daunte Wright. That is what she was charged with. So we're witnessing the trial in front of our eyes. Kenpotter testified earlier in the day. She is expected to continue testimony very shortly. Thank you all for tuning in. We have YouTube, Twitter, and Facebook rolling. If you want to know more information about the Kenpotter trial, check out our website, unicornriot.ninja, and click on that Kenpotter trial graphic. We have some short summaries. We have how we got here and some other information in there, as well as other streams that we've had throughout the days. We're looking at a live court feed. On the right side of your screen, it is 1:29 Central, and it's 1:29 p.m. in the Central area. The court is downtown Minneapolis at the Hennepin County Government Center. They're up on the 18th floor, I believe 1856. The seal of the state is 1858 is written on there. You heard Dan talking about a little bit of the imagery of that seal the other day on the stream, but 1858 is when Minnesota specifically got that seal. We are looking like we are ready to go.
Okay, please be seated. Miss Potter, could you take the stand again?
You owe me.
Did you want to say something, Mr. Frank? Oh, you're just standing up. Okay. All right. Are we ready for the jury? Oh, yes. Okay. I had my law clerk send you a copy of a new draft. Okay. Well, we can talk about jury instructions after we get the testimony in. Okay. All right. Thank you, Deputy. Okay, please be seated. All right, counsel, you may continue.
Thank you, Your Honor. Ms. Potter, before we left for the break, we were walking through what happened on April 11th. You'd agree that for a large part of the interaction at the side of the car with Mr. Wright, you were standing behind Officer Lucky, right?
I was next to him at some point.
Okay. And you testified on direct that after you saw a scared look in Sergeant Johnson's face, that's why you decided to use the taser? That was your testimony?
Yes.
But you also told Dr. Miller that you don't know why you decided to use the taser, right?
I haven't seen his report.
Would it refresh your recollection to see his report?
Yes, please.
May I approach your Honor?
You may.
Did you have a chance to look at that, Ms. Potter?
Yes.
And did you see the portion where it explains, when asked by this examiner why she decided to draw her taser, Officer Potter states, "I don't have an answer. My brain said grab the taser." Do you recall that?
I don't recall it, but it's in his paperwork.
So, on April 11th, you reached down and drew your weapon, right?
Yes.
And you said taser, 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 so Officer Lucky and Sergeant Johnson would disengage, right?
Yes.
And they did disengage, didn't they? They let go of Daunte Wright and stepped back.
According to the video.
And after you shot Daunte Wright, you said, "Shit, I just shot him. I grabbed the wrong fucking gun and I shot him. I'm going to go to prison and I killed a boy." You said all those things, right?
I don't remember.
If that's what's in the video, that's what you said, right?
Yes.
And you said that there are a lot of things that you don't remember, and that on direct you testified that your memory came back when you saw your husband that day. But didn't you tell Dr. Miller that you remember seeing the gun in your right hand? You said that, right?
I don't remember. My interview with him, I was distraught. I wasn't in a good place.
After you shot Daunte Wright, you didn't behave like someone who had just saved Sergeant Johnson's life, did you?
I was very distraught. I just shot somebody. I've never done that.
Well, you never asked Sergeant Johnson if he was okay, right?
I don't remember the conversations.
You didn't check in on him at all, right?
I don't know.
Well, you saw the video when Sergeant Johnson fed you the line, "That guy was trying to take off with me." You didn't bite, right? You didn't respond to that at all, did you?
The video, I was crying. I was in shock.
And he was trying to make you feel better, wasn't he?
The objection is sustained.
Well, he didn't remember saying it, right? You heard that testimony?
Yes.
And you don't remember him saying that, right?
No.
And you didn't say anything like, "Thank God I shot that guy and saved your life." You didn't say anything like that, right?
The objection is overruled.
You didn't say that, right?
No.
And you didn't ask Sergeant Johnson anything except to call Chuck, right?
I don't remember what I asked him.
That would be on the video, right?
Yes.
You'd agree that as a police officer, you have the duty to render aid and communicate information to other officers, right?
Yes.
And it's part of your job to assist those who are hurt or injured. True?
Yes.
And to communicate to other officers what you know about a particular scene, right?
Yes.
Give them whatever information you can to help them do their jobs, to help render assistance, things like that, right?
Yes.
But you didn't do any of those things on April 11th, did you?
No.
You stopped doing your job completely. You didn't communicate what happened over the radio, right?
No.
You didn't make sure any officers knew what you had just done, right?
No.
You didn't run down the street and try to save Daunte Wright's life, did you?
No.
You didn't check on the other car that had been hit, did you?
No.
That all happened just down the road from you.
Yes.
You were focused on what you had done, because you had just killed somebody.
I'm sorry it happened. I'm so sorry.
Ms. Potter, from your reaction today, and from your reaction on your video, you didn't plan to use deadly force that day, did you?
No.
You didn't want to use deadly force, did you?
That's irrelevant. If she planned it or wanted it, it's a constructive fact.
The objection is overruled.
You didn't.
No. No.
Because you knew that deadly force was unreasonable and unwarranted in those circumstances.
I didn't want to hurt anybody.
You didn't want to hurt anybody, and you didn't want to kill anybody.
No.
And that's why you said, I'm going to go to prison.
I don't.
That's 3 times now, Aaron. Repetition.
All right. The objection is sustained.
Ms. Potter, you know the difference between left and right, don't you?
That's objective now. She's asked that before. It's argumentative.
It's not been asked, Your
The
Honor.
objection is sustained. It's argumentative.
Nothing further, Your Honor.
Ms. Potter, do you need a break?
No.
Okay.
Yeah, Johnson Lucky. Just going to ask you a few questions. Do you remember your visit by Zoom with Dr. Miller? A little bit at least.
We had a Zoom interview, yes.
Okay, and that was Miller in Florida, correct, as far as we know?
Yes.
And you and me were in my office, correct?
Yes.
And that was the first time that you had ever seen any of the video, correct?
Yes.
And were you able to watch it?
No.
And you did tell Mr. Miller that when Wright pulled away and got back into the driver's seat of the car, which was still running, Potter, that you could observe Johnson and Lucky struggling over the console, and it appeared that Johnson was trying to prevent Wright from putting the car in drive.
Objection leaving.
The objection is overruled.
If you don't remember that, because it was a while ago, I can show it to you to refresh your memory.
I don't remember.
May I approach, Your Honor?
Remain.
Read to yourself, Ms. Potter, the last sentence of the second to the last paragraph. Does that refresh your memory as to what you told him?
Yes.
And did you tell him that? Pardon me, I didn't hear you.
If it's in there, I must have. That day is so blurry.
Did you also tell him that you yelled taser, 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 so your partners would disengage from Wright?
Yes.
And just a few more questions here. Would it be routine, thinking back when you're a law enforcement officer for 26 years, would it be routine for you to unsnap your holster on the way to a car?
No.
And why not?
I'm only 5'3". If I would get into a fight, I could lose my gun.
Did you ever, in your career, shoot your gun at anybody?
No.
Did you ever shoot your gun in real life during your career?
No.
And did you ever shoot your taser during your career?
It was never deployed.
Is that what it means?
Yes.
And that would be real life. That would be when you have to use those weapons, that would mean it was an emergency situation, would it not? Well, what would it mean to you? Yeah, sorry. Thank you, Judge. What would that mean to you if you had to shoot your weapon?
That I might kill somebody.
When you three law enforcement officers, and excuse me, by the way, as far as reporting this shooting, would it be Sergeant Johnson, your boss, would be the one that would be required to do that?
Objection leading.
Well,
Well,
rephrase it.
that. Who would be required, according to policy, to report the shooting? Would it be the shooter or the other person who was in charge there?
On that scene, it would have been Sergeant Johnson.
Because he was your supervisor, correct?
Yes.
Then I got a couple more questions. If you stopped a vehicle in Brooklyn Center and you learned that there was a bench warrant for a weapons violation, you learned that there was a temporary restraining order a female had lodged against the person that said he was in the car, that gave his identity, but he really did Mr. Wright ever give a valid identification for himself?
No.
And the other office, now you've got no valid information, you've got a gross misdemeanor, you got a temporary restraining order, you got marijuana smelled by your partner, you got no license, no insurance. Would you let that car go if you went up to it and were attempting to handcuff the individual and the car, he jumped back in? Would you have thought you should let him go, drive down the street?
No.
On the temporary restraining order, if you learn there is a temporary restraining order, is it protocol? Is it policy to, as soon as you learn that, jump out of the passenger side, run up to the car and ask the lady what her name was? Has that ever been heard of in police practice that you know of?
No.
Thank you, ma'am. That's all I have, Judge.
Is there any recross?
Yes, Your Honor. Potter, you were asked about some statements that you made to Dr. Miller on redirect, right?
Yes.
You also told Dr. Miller that you resigned on April 12th to protect your police family, right?
Judge, I object to this improper re-cross-examination. I never got into that. I just got
Okay,
into one statement.
Your Honor, the statements to Dr.
Yes.
Miller are at issue.
I'm going to overrule the objection. You may answer that.
You told him that, right?
Can you repeat the question?
You told Dr. Miller that you resigned on April 12th to protect your police family, right?
If it's in the report, yes. I haven't seen the report except today.
Well, if it's in the report that you also said that they're very important people to you, would that be accurate?
Yes.
You have a very close relationship with the police officers, other individuals you work with or used to work with at Brooklyn Center, right?
Some of them.
Sergeant Johnson is a good friend of yours.
Judge, I object to this. It's outside the scope.
The objection is sustained beyond the scope.
You also told Dr. Miller that you don't make mistakes, right? You told him that?
If it's in the report, yes.
And you told him that you don't want to hurt or injure anybody, right?
Right?
But you mentioned to Dr. Miller your relationship with the individuals that you work with, right?
Yes.
And that was very important to you, right?
Yes.
You advocated for their interests in a lot of settings, didn't you, for the people that you worked with?
I advocate for everybody.
You had a very close relationship with them. You referred to Sergeant Johnson as a rock star, haven't you?
I don't know when I would have done that.
Nothing further, Your Honor.
Go ahead, Mr. Gray.
In all of your years there as experience in all of the patrols that you conducted, did you have to rely on your partners for assistance anytime you did a stop or an investigation of any nature?
Yes.
And that would be the family of the police department at Brooklyn Center, correct?
Yes.
And they were your second family, weren't they?
Yes.
As far as complaints, in the 26 years that you were a police officer, did you ever have one citizen complaint?
Objection, Your Honor, outside the scope.
The objection is sustained beyond the scope.
I have no further questions.
Any further cross?
No, Your Honor.
All right. You may step down.
Thank you.
Thanks, Russ.
Does the state have rebuttal?
I'm sorry, Your Honor.
Does the state have any rebuttal witnesses the defense has rested?
We do not, Your Honor. Thank you.
Okay. All right. Members of the jury, all the testimony is in. So what's going to happen is that on Monday morning, I'm going to give you the instructions of law you need to apply in rendering your verdict, and then the attorneys will have a chance to do their final arguments to you. Now, so we're starting on Monday. I've got to read the cautionary long version again so that you don't do any research. Don't let outsiders influence you. This includes family members and friends and anyone else who is not actually involved in this trial. Don't discuss the case with other jury members during the trial. Again, you'll have plenty of time to do this at the end of the trial. Once you have had all the evidence, I've sent you to the jury room with my instructions and the verdict forms. Don't talk to anyone involved in the case, of course, the defendant, the lawyers, or the witnesses. If anyone tries to discuss this case with you outside the courtroom, please report this to me. When you go home over the weekend, do not talk to your family, friends, or others about the case. You may tell them that you are a juror on a criminal case, and that is all that you should tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, LinkedIn, Google, YouTube, or other social networking sites about this trial, even if I have not specifically mentioned other social media sites. Don't visit any chat rooms where this case may be discussed. Do not read or listen to news reports on newspapers, magazine, radio, television, podcasts, or other media about this case. Don't do your own investigation. Do not ask people about the case. Do not visit any of the locations mentioned in the trial. Do not use internet map applications such as MapQuest or Google Earth or similar mapping media to view the locations. Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media, including Google, Safari, Firefox, Bing, or other similar search engine. Do not create your own demonstrations or reenactments of the events which are the subject of the case. Remember, you can't consider anything you hear or learn about this case outside this courtroom. If you don't follow these instructions, again, you may jeopardize the trial and we might have to start all over again. If you become aware that another juror may have violated any of these rules, you need to let me know that. Okay? So, members of the jury, first of all, I want to thank you for your attention during this trial. I want you to have a good weekend, and we'll reconvene on Monday at 9 o'clock. Right, please be seated. Okay, counsel. Okay. All right. All right. Okay, you should have received another draft of the jury instructions by email. I had Zach do this, or Mr. Kramer do this in 14 points, so us older folks can read it. Okay, so new draft. Okay, I'd like to have a discussion about jury instructions this afternoon. Why don't we force? I've got one in here, a clarifying provision in it, but I'd like to see yours. So a half an hour should be enough? Okay. Okay, we'll reconvene at 2 2:30.
Can Ms. Potter be excused?
Yes, you may be excused. I mean, she's coming back for jury instruction argument, right? Okay. So, 2:30.
There we go. Got the right screen up. Apologies for that last little bit. So yeah, what you just heard was sort of not the end of today. We're coming back at 2:30. Let me get this little clip up correctly. And once we come back, it sounds like we'll hear about the jury instructions and whatnot. And so that's going to be interesting to see what they're talking about with some of these instructions. Let's see here. There we go. So again, thank you all for tuning in. Wow. Kenpotter testified. Kenpotter cried. Kenpotter was sort of grilled by Aaron Eldridge around sort of like maybe the 1:38 mark, 1:38 p.m. Central Time, which is the video marking of the time. If you end up going back in the stream, that is when sort of Aaron Eldridge was asking Miss Potter why she didn't render aid. You know, she just shot Daunte. Nobody called it in. At one point, she was even asked, well, the defense sort of was like, well, isn't that Johnson's job to call it in since he was a supervisor or like the sergeant at the time? And so, again, like sort of some of these officers are throwing blame on the other ones for their mishaps within following procedure and whatnot. And that's consistently seen in most cases where you have different police officers testifying about the same situation, and somebody's trying to either provide culpability or there's trying to be some accountability pushed. So we have 30 minutes here. What we're going to do is we're going to show you some footage from April 13th. This was 3 days after 2 days after Daunte Wright was killed. He was killed on April 11th. You remember, I'm sure you all do, if you're watching this trial. He was killed on 63rd near Catherine. That's where the car ended up crashing after he was shot by Kenpotter during the traffic stop. We saw Kenpotter specifically talk about, you know, what she was thinking when she grabbed the gun. You know, it sounded like she never fired a gun and had never fired a taser on her job at all in all of the 26 years. It sounds like she has no complaints. I haven't been able to find any personally. I don't know if I've seen any other journalists with complaint listings of Kenpotter. We did hear during the jury selection a person specifically pertaining, specifically bringing up a case of her friend having a run-in with Kenpotter, sort of signaling that Kenpotter has been or was acting racist in that incident where she was specifically talking to a white woman who had a black boyfriend who Kenpotter didn't approve of, essentially. We also have heard from different community members since Kenpotter has been, you know, not the most friendly towards folks in the community, certain folks. And so we also do know Kenpotter's involvement in Kobe Heisler's murder. She did not murder Kobe Heisler. Kobe Heisler was a 20-year-old, I think 20, was shot and killed by Brooklyn Center police officers in 2019, I believe. Kobe Heisler, we're going to show you a real quick little clip from when the officers who killed Kobe. So Kobe was Kobe had autism. Kobe had a bad day. His grandfather called the 911, ended up calling 911 back and saying, hey, don't come. We don't need the mental crisis check anymore. Everything is calmed down. The police sort of just came anyway. they continued to pressure and pressure and pressure the situation over 15 minutes of just like badgering the family, separating the family, talking to people. And then like Kobe like moved around and they didn't like how he moved. Some say he had a knife. They then killed him in the living room of where his grandma and grandpa lived, and his grandma was right there. Incredibly horrid scene. We've heard from Kobe's mom and Kobe's family multiple times in the past, and we've seen them at some of these protests lately in these last couple of years. And we're going to roll a little clip of that before we go to the April 13th, because we're going to show you real quick Kenpotter at the scene right after basically the two officers had killed, excuse me, let me stop this real quick. Right after the two officers had killed Kobe Heisler. Again, she is working as a, union representative at this point. She comes on the scene and is like, oh, so two officers have killed somebody. I need to do my due diligence as a union rep to sort of make sure that they're going to be looked after. So she instructs them. She sort of checks them and then instructs them, checks them by patting them down, and then instructs them to turn off their body cams and don't talk to anybody. And so, some of that is standard procedure, but this is sort of what you see where when it comes to what people perceive as possible cover-ups. So then she's telling them to turn off their body cams right then. But then later on, there's like discussions that they do have. And she's part of understanding the whole rubric around investigations that happen after a use of force incident. She's been a veteran officer for 26 years. Again, her husband is a veteran officer for 27 years before he retired. He was in Fridley Police Department. She's in Brooklyn Center Police Department. So, you think about all that. Here's the Kobe Heisler body cam. This little clip was provided to us by Amity Dimmick Heisler, Kobe's mother, and we're going to show this real quick. We're going to let it roll, and then I'll be right back.
Shut your body warns off and go to your cars and don't talk to each other. I'll be over to take you in a minute. Go to your cars and don't talk to each other. I'll be over to take you in a minute. Shut your body warns off and go to your cars and don't talk to each other.
So that's just Kim on the job 2 years ago after they killed Kobe Heisler, acting as a police union rep, essentially, trying to make sure that the officers don't talk to each other to corroborate their story at that point. And so, again, Kim has been around for a long time, 26-year vet. We are going to real quick show you the clip of an interview with Amity Dimmick Heisler, who's Kobe's mother, and this was filmed, I think, 2 years ago, last year. We'll show you this, then we'll come right back and we'll continue the discussion. Again, this is not Daunte Wright's family. This is Kobe Heisler's family. This is related because Kenpotter just got off the stand. And if you want to check out her testimony, where a lot of it really sort of got cross-examined pretty clearly by the state, it's about at the 138 mark. So if you're just like on break, you're catching up to this and you want to go back and check out Kenpotter's testimony, check it out at about the 138 mark Central Time with the video monitor up in the top right. So we're going to roll this Amity interview. It's a very short interview, and then we'll be right back with you.
Thank you so much for taking the time today. Can you tell us a little bit about your son?
My son Kobe, he was the most beautiful boy in the world. He was loving. We like to call him a gentle giant. He stood probably that high over me. One of his favorite things to do, actually, as I was going through looking at all the pictures, trying to find pictures for his funeral service, was really like to just rest his head on top of my head. And I saw that in just numerous pictures. The other thing that I realized that he really likes to do, that I caught numerous pictures of, is he loved picking his little sister up. Like when he started getting big, that was his favorite thing to do, was just pick her up. And I have like a million pictures of them just laughing, you know, him holding her and And I don't know, all I can say, you know, he was nonviolent. So, and still to this day, I haven't looked at the videos that they uploaded. I've heard about them. I haven't read the report from the district attorney. I haven't read any of the whatever the heck is out there. I don't need to. I know my son. We all knew my son. He was never a threat to anybody but himself. And all that I know is that police responding to mental health or autism sorts of situations. There's zero reason. The statistics show that that person generally ends up dead or injured, but certainly not helped. So there's a lot of work to do, and that's kind of where I'm at, because that's all they left for me to do for my son. Fight for justice, and also most importantly, like, give him a legacy, you know? Give him, I won't let them put his name out there and vilify him in any way. I'll fight against that till the day I die, because he was nothing but a beautiful, beautiful person, and he didn't deserve this.
So that was Amity. That's just, you know, some of the pain represented by these family members who have to deal with this situation of police killings. Very, very deeply impacting their lives and their everyday life. We're going to kick it over to a clip from Mike Elliott. We interviewed Mike Elliott this last year at the George Floyd Square during the 1 year remembrance of George Floyd. And Mike Elliott is the Brooklyn Center mayor. And he specifically, I'm going to show you his face real quick.
Can you introduce yourself and say what it's like?
Not letting me stop real quick. Mike Elliott is specifically the Brooklyn Center mayor. He has come together with sort of the community, essentially, and created a new Department of Public Safety, and has called this sort of new bill the Daunte Wright and Kobe Heisler Act, something similar to that. And what that specifically is pertaining to, he's going to describe. And so they just sort of got the funding for that, I think, very, very recently. And so we're going to kick you over to that. Again, the Kenpotter trial is on break. Kenpotter has testified. The defense has they've rested their case. Now we're at the moment where jury instructions will be talked about, and then some other motions will most likely be ruled on. And it looks like from there they will set up closing arguments for Monday, and then we might be looking at the jury being in deliberation from Monday into the week of next week. So again, thank you all for tuning in. If you missed the Kenpotter testimony, I will real quick run a quick update. She was on the stand for a few hours. Earlier today, we also heard from a Dr. Lawrence Miller, who the defense have brought on, and he talked about weapon confusion. He talked about basically the mentality that goes around drawing weapons and use of force and policing. Kenpotter took the stand. It sounded like she had some family members inside the courtroom. We know that Daunte Wright has also had family members inside the courtroom. There's also overflow for both of those families to be in a different courtroom and watch the proceedings. We heard a few times during the defense trying to bring Kenpotter to life. She really was sort of straight-faced through it all. She started to cry during the times where she was recounting the day of April 11th. It sounds like it's really muggy in her head. She doesn't really remember a lot of it. There was a lot of back and forth when the state was doing the cross-examination, specifically at 1:38 this afternoon, about 30 minutes ago or so, there was a lot of sort of going at it from Aaron Eldridge to Kenpotter. So check that out if you want to go back. We're going to play this clip of Mike Elliott that sort of draws into Kobe Heisler and Daunte Wright's connection and how it possibly is pushing a new way forward for public safety.
Can you introduce yourself and say what it's like here at George Floyd Square 1 year on?
So my name is Mike Elliott. I'm the mayor of Brooklyn Center. 1 year on here at George Floyd Square. The atmosphere is peaceful. There's a celebration of George's life, and it's very hopeful, I would say, in terms of, people's outlook on what the future is going to bring and the kind of changes that the community really is looking for. And so I think tonight is about a celebration, but it's also about a look to the future to make sure that the changes are put in place so that there isn't another George Floyd, there isn't another Daunte Wright, or Tamir Rice, or Ahmaud Arbery, or the list goes on and on.
And you brought up Daunte Wright. Thank you. You're the mayor of Brooklyn Center, where Kenpotter, the officer who killed Daunte Wright, was working for. Quickly, you seem to have brought about a lot of changes, reforms very quickly, within a couple of weeks, right after. Can you talk about what happened in Brooklyn Center with Daunte Wright, and then talk about some of the reforms you were pushing for and you were able to successfully push to get?
What happened with Daunte was tragic, and it should have never happened. And myself, I believe that. My city council members believe that. My community really, through a series of listening sessions, almost immediately following the killing of Daunte, the community really stood up and said, enough is enough. It's time for change. It's time for us to have real transformation that's going to lead to a public safety system where everybody feels safe. Not just some people, everybody. And so we got to work right away, putting together legislation that we think could have prevented the death of Daunte Wright. And it's a very comprehensive package that we put together. I think that probably the most sweeping piece of legislation that that's been enacted anywhere in the country, which includes putting the police department along with their fire and two new departments, a Department of Community Response and then a civilian traffic enforcement department. These two new departments that we're creating underneath a Department of Public Safety and Violence Prevention, which is going to be led by someone with a background in public health. So the person leading all four of our public safety departments is not going to come from a law enforcement background, but from a public health background. So that person is going to be looking at the data and the sciences and looking at what we need to do to keep our communities safe from that lens. Important to that also is that we're putting together now a mental health response team that's going to be made up of mental health professionals that will respond to emergencies, as opposed to having law enforcement respond when there's a behavioral health or mental health situation that's unfolding. We want people who have been trained in those areas to show up and actually provide care. And there are models of this all around the country where it's been extremely successful. And then we're putting together traffic enforcement that, number one, there will be no arrests for low-level misdemeanor, non-felony violations, right? And number two, we're going to limit what police can pull people over for in the first place. So no more we're going to have those pretextual stops where they pull you over because of a taillight or because of an air freshener or because you didn't put the turn signal on here or for any number of reasons or expired tab where they tend to pull people over and use that as an excuse for searching your car and arresting you and so forth, right? And even here in Brooklyn Center, we have had, I think maybe about 70% of the stops in Brooklyn Center from police were done, were stops where they're pulling over African Americans, even though African Americans are 30% of the population, right? So we know that there are some real disparities in policing in Brooklyn Center. So we're turning the page, and we're taking full accountability for transformation that needs to happen, and we're hoping that other people, other municipalities across the country will follow suit and enact some of these changes as well.
How long will these changes take to take place to be instilled into reality for everyday Brooklyn Centers?
Right away, I think within the next 2 weeks, we're going to implement a citation and summons only policy. So for some of these, low-level, non-felony violations, the police are no longer going to be arresting people. They'll maybe write a ticket and say, go ahead, you have to come to court, but no more arrests for those. And that policy we anticipate will be implemented in the next 2 weeks. Absolutely. And then the other portions of the reforms, we're going to stand them up as quickly as we can, as soon as we can write the policies and hire the people that are going to be doing the civilian and hire and train the civilian traffic enforcement folks and the mental health folks. I would say definitely in less than a year is what I can say right now, and we're going to be really ambitious about that because on average every 18 months the police shoot and kill someone, right? And we want to make sure that we are having these systems put in place before that can happen again. So keep a lookout. Over the next few months, we're going to be rolling out various aspects of the reform, and we're going to get it up and running hopefully in less than a year.
Wow. Can I ask you real quick? I know you probably have to do things, and thank you for taking this time. What made you in your position so quick to make these changes and implement these changes where even in America we have George Floyd, and a year on we have the George Floyd Policing Act, which really doesn't even instill some of the changes that you're pushing forward? What happened here? How did you do this?
Well, number one, I have to thank my city council, because my city council ultimately approved these changes, and they, bought in to the science behind the changes that we're implementing and the research. And then my community stood up, and the community came out in droves. Black, white, people of all backgrounds came to these listening sessions, and they demanded the change, right? And for me, being in this position, I've had personal experiences with police myself, right? Where I have been, taken in, been arrested, or been stopped, right? Because I quote unquote fit the description. I've been pulled over for some of the same reasons, the pretextual stops. So for all of those reasons, both our community standing up and saying that, demanding that it's time for change, and then myself and many of my city council really have had either direct experience or experience with police through members of their family. I think all of these factors came together and helped us move forward very quickly. But the most important thing is our community stood up, and our community said, enough is enough. It's time for change. It's time to act right now. And for me personally, this has been a scourge on all of our communities across the country for far too long. We have the ability to start making change now, so we're going to start right now. That's just my view on it.
Anything else you'd want to say?
No matter what community you're a part of, this is now the time for change. Mobilize, run for office, contact your representatives, create spaces in your community where you can start to build power, build coalitions that are going to demand change. And if you all stand up and demand the change in your community, you can have it. I truly do believe that.
Thank you very much. Appreciate you spending
Yes, sir.
time.
Yes,
Thanks.
sir.
So that again was Mayor Mike Elliott, Brooklyn Center mayor, and a lot of what he was talking about has now, I think, been funded, and now they're making moves to finally make that enactment happen. And so we'll see if that has any effect on police violence towards the community and stopping police killings that continue to happen. It's a thing where the community has been calling out for some accountability for this for a long time, especially in the local Minneapolis, St. Paul scene, as well as across the country. So we're sitting here. There's 5 minutes about left in this break. Some of what Mayor Mike Elliott was speaking about was the community coming out in droves, not only to the community listening sessions, but in the beginning, after Kenpotter killed Daunte Wright, the community came out in droves. So if you weren't around during that time, or if you don't really remember seeing what was happening during that time, there was about at least 7 to 10 days of consistent large protests outside in front of the Brooklyn Center Police Department. They had quickly fortified it with concrete barriers and fences, as was Kenpotter's house right after she killed Daunte. Her house in Champlin was also very fortified, and so that was a fact. The police were guarding it. There was concrete barriers with fencing around it. But we're going to bring you over, while we have some time, bring you over to April 13th. On April 13th, there was specific action that went sort of like aimed at the FBI center. Minnesota's FBI building is really close to the Brooklyn Center Police Department, not too far, and it's right off the freeway. It's off of 66. And there was a large protest that went by it on April 13th, and then also there was a protest at the government center. It's very cold, sort of blistery, rainy, but snowy, one of those rainy, snowy April days in Minnesota. So we're going to kick you over to that just for a brief time, and then once court's coming back, we're going to kick you back to court. So we're watching the court feed. We have the court audio on as well, and we are watching that once we have any movement. Again, like I said, we'll be right back over to you. So we're going to kick you over to April 13th in front of the FBI Center, a block or two down from that. Appreciate that. Yes. How's it going? All right. Yes. Come on out. Out of your house. Justice, no peace. Prosecute the police. What up? What up, man?
We do this every night. Stay right. We do this every night. Stay together. Stay right. We do this every night.
Attention all media personnel, you are to vacate to the north. All media personnel, you are to vacate to the north.
This is the Minnesota State Patrol. You're in violation of Minnesota State Statute 60705. If you do not cease your unlawful behavior and disperse peaceably, if you continue to obstruct, resist, and/or interfere with peace officers, you will be violating Minnesota State.
Sorry for that quick cutback.
All right. Counsel, we're gonna, did you want to say something, Mr. Gray? I'm behind plexiglass. Okay. All right. If you're if you're speaking, you could take your mask off. Okay. All right. All right. Let's go through this page by page. Okay. You have our most recent draft, the one Zach sent you. Anything on page 1? Page 2. Page 3.
Nope.
Page 4. Okay, page 5. Okay, now we're at page 6. Do we need a superseding cause instruction? It is in here. I was just wondering if it's at all applicable. Okay. You don't.
What I understand the argument's going to be is that by fleeing, he's the cause. It can't, as a matter of law, be superseding of the events. So, no, a superseding cause is not just.
Part of the case, you can't mandate that it's not.
Okay, I'm going to keep it in, okay? Anything on 7 that you want to object to? This is... Okay, now we're at 8. And I've changed down at the bottom. I've struck affirmative defense and just left it at defense. The jury's not going to understand what affirmative is. or it isn't. So it'll say defense hyphen authorized use of deadly force by a police officer.
You shouldn't put good defense. No?
The version I have, Your Honor, it does say affirmative, so you're taking that out. Since
We're taking out affirmative because nobody understands what that means. All right. And I think the state wanted to be heard on my change to the standard instruction on the kind and degree of force. The standard instruction did not have the hindsight language, which is in the standard instruction for non-deadly force. Or has the state withdrawn its objection?
No, Your Honor, if I can just make a record about that, we did.
Sure.
Can you hear me okay? So the state's position, Your Honor, is, first of all, that the use of non-deadly force instruction should not be given. I realize we're not at that point yet. But the hindsight language, we oppose the inclusion of that. And so if we're looking at page 9 of the proposed instructions, that last full paragraph, there is a sentence about halfway down that says the reasonableness of the particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the benefit of hindsight, taking into consideration split-second judgments, tense, uncertain, and rapidly evolving. I think we all are familiar now with that language. It's that language, Your Honor, that we feel the court should not include. Prior to that sentence, maybe I'm doing this backwards, is the sentence that says to determine whether or not the actions of the police officer are necessary, you must look at those facts known to the police officer at the precise moment she acted with force. We think that's appropriate, and that's an accurate statement of the law. All that follows is simply repeating that same concept, that, in other words, that we're limited to looking at what the officer knew at the time, and is unnecessary language, because that's already included in the instruction. That language is, we heard testimony from Professor Stoughton, and I think might have been Mr. Imes, or one of the trainers anyway, that explained that 20/20 hindsight language is about that very concept. You can't look at facts that occur afterwards. My central issue continues to be with this additional language that comes out of appellate decisions in immunity cases where the appellate court is essentially telling the lower courts in granting or denying immunity, you can't be looking at these things that we know or learn later. And so their appellate language, I get it, they're in an appellate opinion, and that's probably why they end up in the jig. But the reason I think they're inappropriate for a district court jury instruction is because they have the force of the court's authority behind them, and they're singling out specific facts for the jurors to consider. And that's why that additional language is improper in addition to being unnecessary. It's just a way of saying, also consider these things. So in other words, when we have a jury instruction on impeachment, the court gives, hey, you could consider some of these things, but we don't go forward and say people who use drugs are not as reliable. You know what I mean? We don't use it. We don't tell them how to think about certain things. And that's what I think this language does and is improper. My feeling that what probably happened is the writers of the jigs saw that language in the opinion and included it. Our position is it's unnecessary and actually improper to add it. That is our objection to that language.
Okay. Mr. Ng.
Are we persistent in its inclusion? We had a discussion about this in chambers. This is consistent with Graham versus Connor, and we would prefer then ask you to keep this language in as it is.
Okay. Two things. First of all, the U.S. Supreme Court has specifically stated that this is an appropriate consideration in determining reasonableness. And number two, it is the standard jig for non-deadly force. And I'm just using the same standard in the deadly force instruction. So that hindsight language is already part of the standard JIG for non-deadly force, but not for deadly force. There's no reason why it shouldn't be in the deadly force instruction. Okay, state's objection noted. And then number 10, at the top, the title should be use of non-deadly force, and strike authorize and strike defined. Then I like the state's suggestion on explaining this taser use. Did you get a copy of the state's? Okay.
We did get a copy of it.
All right. They're saying, in this case, you have heard testimony about whether, first of all, is the state objecting to any instruction on non-deadly force?
We are, Your Honors, as we argued before, the only use of force at issue in the case is the firing of the gun, which clearly is deadly force, and so we continue to take the position that the jury should not receive an instruction on the use of non-deadly force.
Okay, and I've overruled that objection because the state's expert stated that the use of the taser was unreasonable and inappropriate. So the state's expert really made it an issue. So, Mr. Ng?
Yes. Well, we read the state's proposal. We would object to the first sentence of the state's proposal and the last sentence, and then leave the balance of the instruction in.
Your Honor, I'm not going to argue that authorized use of non-deadly force is a defense at all. I might argue about it, talking about Professor Stoughton, Mr. Professor Stoughton, but I'm not going to claim that it's unnecessary. I mean, if I do, are you going to instruct before or after the arguments?
Before.
Oh, okay. Well, then I can do it.
Okay, and you know, I like the state's language. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. I think that's accurate. And I would go down to the statutes of Minnesota provide that a police officer is authorized to use reasonable force in the line of duty, period.
Now, we would like you to say in executing a valid arrest warrant. Yeah.
Well, you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. That's so subparts 1 through 4 are just duplicative and confusing. So there would be a period after line of duty, and we would strike 1, 2, 3, and 4 and go straight to you're instructed that executing a lawful arrest warrant is a duty imposed on officers by law. And then the standard instruction on reasonable force. And I also like the state's suggestion on the explanation whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
It's not an absolute defense, I think we should put, because the evidence that's entered into this case, and this professor says that that was a violation too. So I just think that if you're going to comment on it, but is whether the defendant's apparent decision to use a taser was reasonable or appropriate is something you may not consider in order. Well, leave it alone. I'll argue. No problem, Judge.
Okay. Are you withdrawing your comments?
Pardon.
Are we okay with the state's proposal then?
Well, I I'm in a state of confusion.
What? The actual language, whether the defendant's apparent decision to use a taser was reasonable or appropriate, is not a defense to the charges in this case.
But I can't argue, Judge, that her decision was appropriate as far as she was concerned.
Yeah.
She testified to that.
Yeah. You can argue that she could use a taser under the circumstances.
I do have a question.
But you can't say that she's not guilty of either charge because the use of the taser was appropriate.
Yeah, but it shows circumstantial evidence that she was in good faith, that she wasn't intentionally doing anything devious.
Okay, you can't argue that it's a defense. You can't say she's...
I argue it as a defense.
Yeah.
But I am going to argue that Mr. Stoughton said that in his incredible opinion, he said that even what she did with the taser was unreasonable and appropriate. Read the instruction about Mr. Stoughton's opinion, and I'll point to it. That's all.
Okay.
So are you doing in toto the state's proposal here? Are you substituting it all in? Or are you just, help me with what you're doing exactly at the top. I may have missed it, and I'm sorry to indulge.
Okay. I am adopting the state's proposed language, the introductory language. So it'll say, use of non-deadly force. That's the title. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. And then the last sentence would be whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case.
Are you going to cross off the state's 1 through 4 sentences? I think you are.
Right, 1 through 4. 1 through 4 is effectuating a lawful arrest, executing legal process, enforcing an order of the court, or executing any other duty imposed upon the officer by law. I mean, right under that, it says you are instructed that executing a lawful arrest warrant is a duty imposed on officers by law. Do you want additional language in there?
Well, we would like executing legal process, enforcing order of the court. I mean, what we asked for was the statute, 609.06, and the language of the statute.
Okay, we can put the... Okay, we'll put it... With all due respect. Okay, we'll put that back in. Okay, now, anything on 11?
Can I just make a record about this?
Yes.
So I indicated before, I think, so it may not need repetition, but I will, just our continuing objection to have this instruction in at all. And I want to point out that we also, of course, have the objection to the hindsight language in the definition paragraph here, consistent with the court's other definition of it in the deadly force. And then, Your Honor, I should point out, that that paragraph is different as well, just so we're all clear about this, in the first line, where in the deadly force instruction, it starts out saying, as to each count and defense. Right? So do you see what I mean? In the deadly force instruction, that last paragraph starts out as to each count or defense. I did not include that in the non-deadly force definition so that there wouldn't be any confusion when we go on and tell them this isn't a defense, right? I just want that clear to everybody. So that, and then, Your Honor, if we're going to if we're going to reinsert paragraphs 1 through 4, I would ask the court to take out arrest in the next sentence. You are instructed that executing a lawful arrest warrant. All the testimony in this case has been that it was a bench warrant or a warrant, And so to call it an arrest warrant, I think it misstates it.
I just noticed, and I've had a few of these, what we missed here, and I walked by, at the, on page 7, on count 1 and count 2 both, at the end of them, when you find, if you find that each of these elements been proven beyond a reasonable doubt, the defendant is guilty. If you find any element that has not been proven beyond a reasonable doubt, the defendant is not guilty. In addition, if you find that the state failed to prove that reasonable force, give me the language
Well, once self-defense is raised, they have to prove it beyond prove she didn't act in self-defense beyond reasonable doubt.
Yes. So that should be in here, because otherwise they say, well, the judge says if they prove these elements, he's guilty. But you got to warn them. Look at the self-defense or reasonable use of force instruction. That if the jury finds that it was reasonable use of force, they're not guilty. So you got to put in there that
once you raise the defense, they have to disprove it beyond reasonable doubt.
Right. It is on page 10 at the top of the page.
You know what my argument is with the last paragraph of count 1 and count 2, where you tell them if the elements are proven beyond a reasonable doubt, the defendant is guilty, unless the state whatever. You have to put that in there that the state has the burden of proof to prove that reasonable force. There's a language. Probably don't call.
Yeah, I'm sorry if I may.
It's in here.
At the bottom of page 8 is when the court's instructions start talking about defenses, it plainly says Minnesota law provides that no crime is committed and the police officer's actions are justified. And then, of course, as the court pointed out, at the end of the instruction, it says they're not guilty of a crime.
Mm-hmm. So it's in there. You're covered. Okay. All right. Let's go back. Let's go back to page 9, the last full paragraph. I'm wondering if the language that says as to each count or defense is confusing. Okay. Leave that the way it is what the defense says, right? Okay. All right. I shouldn't have brought it up because everybody agrees, right? All right. Where were we? Are we on page 11?
Well, I think we're all done with the non-deadly force changes. I did ask, Your Honor, to have the court remove arrest between lawful and warrant in the non-deadly force instruction.
You know what? I'm going to leave everything in there. You know, I just tried to make this a little bit easier for the jury, but if the defense wants it in there, I'm going to leave it in there. Okay, are we on 11? Anything on 11?
No,
Anything on 12? The implicit bias instruction is incorporated under duties of jurors. So 12 or 13?
Nothing from the state.
Okay. And did you have a chance to take a look at the verdict forms? Oh, okay. No objection to the verdict forms either, right?
They haven't changed at all since the last time.
No. Okay. Here's what I'd like to do. First of all, yes. Oh, I like it when you raise your hand. Okay. He raised his hand first.
Before we transition out of the jury instructions, the defense did request an instruction on policy, and we would like a ruling one way or another. The instruction that I requested via email, which I'd like to read into the record and get a ruling from you. Brooklyn Center police policies are not criminal statutes, period. An alleged violation of a policy is not a crime, period. And we requested that on December 14th, and the court deferred ruling. We do persist in requesting that, and if we would like a ruling one way or another from you at your leisure, but I do want to persist in our...
Okay, I forgot about that. Does the state object? I mean, it's true.
Yeah, it's true but unnecessary. We're defining the crimes for them, and very specifically telling them to find them guilty, you have to find these elements. And it's just not necessary, potentially confusing, to give them a specific instruction about policy.
Okay, I'm going to include it because it's true, and it's an accurate statement. Okay.
I'm sorry. We had requested some language be added to the instruction because it's not incomplete. I mean, it's not complete. And I'm trying to remember the exact, because I don't have it in front of me, but but it can be considered in determining, whether the defendant is guilty, because that's also true. Right? It is evidence in the case, and so.
I'm not going to talk about that. You can't consider that in determining whether she's guilty or not guilty. Plus, I don't know what we're arguing about. The Brooklyn Center policies are consistent with the law. So I'm not going to add that additional language, but where would you like that put in the jury? Where do you think it fits?
Right after page 5, after demonstrative evidence, charges are considered. Fine.
Okay, we'll put it on page 5. Right after demonstrative evidence. All right.
What would the title be?
Oh, yeah. What's the title?
Evaluation of policies.
Consideration of policies? Okay. Consideration of policies. Okay. I'll make the changes and recirculate another copy. We'll do it in 14 inch, okay? So, and if you notice anything at all, any typos or anything, let me know by no later than 4 o'clock, okay? And let's see. Oh, would the defense take the time, please, to look at the thumb drive on the computer that the state has? That because there's a computer, a laptop that's going to go to the jury room, right? And then there's that thumb drive with all the exhibits on it. So I want the defense to stay and look at all the exhibits so that you can confirm that all the exhibits that were entered are on the thumb drive, and check out the computer, the laptop, to make sure that it's clean of any other material. The laptop that goes back with the jurors will not have internet capability, okay? And then tomorrow morning, I just want to put on the record that you've had enough time to look at that, look at the thumb drive exhibits to make sure that's appropriate, and that you've also had a chance to take a look at the laptop and make sure that it's appropriate to go back to the jury room. So we'll make a record of that tomorrow. And Oh, that's okay. Oh, yeah. We'll do it Monday. Okay. I misspoke. Okay. Yeah.
I had just circulated an email to everybody about the 2 defense exhibits. We need to get electronic copies of those to put on the. You're on that already?
I sent you our 2 electronic
Did you?
exhibits. Yep.
Okay. And then we try to keep track of all exhibits that were received, and I, of course, would like to think we are flawless at that, but I would rather seek some corroboration. So if the court has an exhibit list, I'd like to kind of cross-reference ours with theirs, with yours, and then once we do that, we can dump all that onto the electronic stuff we need to.
Okay. Yeah, Mr. Kramer's going to help you with that. Okay, what else? I think that's it. All right, counsel, I just want to tell you that I've really enjoyed having you. It was a really well-tried case on both sides.
I kept making those long objections, okay?
You can't help yourself, can you, Mr. Gray? All right. Okay. Have a relaxing weekend if you can.
All right. Well, thank you all for joining this live stream of the ending of the Kenpotter trial testimony situation. I have a little bit of glitch on the back end. Give me a moment. I'm going to pull up our website. There's our website, unicornriot.ninja. And if you stick around to our Facebook and YouTube feeds, in about an hour or so, we will have the full testimony of Kenpotter up. So where you can see the direct questioning, the cross-examination, the redirect, and the recross. And I think the redirect and recross again after that. So again, thank you all for tuning in. This is Nico from Unicorn Riot. We're going to bring the stream down here at 3 p.m. on this on this Friday, December 17th, 2021. We are sitting at 8 months and 6 days or so since Daunte Wright was killed by Kenpotter. If you want to know more on the Kenpotter trial that we've been witnessing, check out our landing page. That is Kenpotter's mugshot. She was in jail for a brief moment. She got bailed out very quickly afterwards. She continues to get pension. She was able to resign her position. So she will be getting taxpayer money for the rest of her life at this point. If she gets convicted, I'm not sure if that continues to stay the same. We saw the other day Derek Chauvin pleaded guilty in the federal case to human rights violations of George Floyd and the 17-year-old who was only one of many, many victims of Derek Chauvin. And the two things that are a part of that is that Chauvin pled guilty in the federal courts, which allows him to get sentenced to federal prison and have that go concurrently with the state time. And so he's getting transferred from state facility to federal facility, which is much easier time if you've ever been locked up or know about situations within the federal system comparatively to the state system. Federal prison is a lot more cozy. Here was the old proposed jury instructions on the Kenpotter trial landing page. This was, I think, put up earlier in December, I think maybe the first week of December. Very, very short little brief pages, one by the well, actually they both say defendant supplemental instruction. So I was feeling like one was brought by the state and one was by the prosecution, by the defense, but I am unsure on that. Either way, we will continue to follow it. We will be back live Monday morning. I believe there's going to be closing arguments, and then the jury will be instructed as to how they must view the case. That's what we saw a little bit about at the end here with the jury instruction questions. So again, that's a very important part of this, is if she can get charged with, or if she can get convicted of specifically second degree and first degree manslaughter. You see here, there's specifics within this. If you go to our landing page, you can go to the charging papers and see specifically what the charging papers were looking like. She got charged with second degree manslaughter pretty quickly after she killed Daunte, and then charged with first degree manslaughter by Minnesota Attorney General's office, Keith Ellison, when they took over the case. So again, thank you all for tuning in. Check out more of that information on our website. Second degree manslaughter is also, they need to prove, the state needs to prove culpable negligence, creating unreasonable risk. You saw the Blakely notice getting talked about. You saw your first few days of testimony where the state was going hard on the who was the sort of the people that were standing by, the mitigating stances, the civilians in their car who got hurt, and the old man, the elder, his life has changed since then. How it impacted other people, these other officers, you know, how Kenpotter actions might have actually made other people, put them in danger. Aggravated circumstances or aggravated sentencing could come from that. That's going to be decided by Judge Chu. That was discussed over this case. A lot has gone on. You see second degree manslaughter, again, culpable negligence creating unreasonable risk. And then we have first degree manslaughter predicated on alleged reckless use, handling of a firearm. We saw the grilling today by the state prosecuting attorney, Aaron Eldridge. We heard Kenpotter say she didn't want to use deadly force. It's sounded like she basically confessed to using that deadly force and she didn't try to. And now it's on the jury to decide if it's been proven that she is guilty of second degree or first degree manslaughter. I mean, it's obvious she killed him. Everybody knows that. So anyways, we'll see where we go. Thank you all for tuning in. We will again, at about 1:52 is when Kenpotter stepped down. She took the stand about 10:40ish a.m. or before 11 a.m. Central Time. If you go back in the streams, you look at the morning stream or the afternoon stream, she took the stand around 11ish, before 11ish. And then she got off of the stand at about 1:52. That was with the break in the middle. We're going to have the uploaded full version of Kenpotter's testimony. And we'll release that through our Facebook and our YouTube. And on the website at the Kenpotter trial landing page. Again, thank you all for tuning in. This is Nico from Unicorn Riot. We'll be back Monday. In the meantime, continue to follow our work. And we have some new specials coming out this weekend. Most likely a new one from Merjan's series on Target, and then we have a few other ones. So continue to follow our work. We got some things cooking. Thank you all for tuning in. Have a good weekend. Drink some water. Tell your loved ones you love them, and be kind. Peace.